We could be different in the eyes of men, but we are equal in the eyes of Jaja. Road like a road, come and tell them one more time again. Listen. Oh, where is peace? Now we always fight. Oh, where is unity? Now we always talk about. Oh, where is freedom? Now we always die. I wonder where the democracy now we always fight. Oh, where is peace? Now we always fight. Oh, where is unity? Now we always talk about. Oh, where is freedom? Now we always die. I wonder where the democracy now we always fight. This is my nation, a wicked kind of nation. You wake up in the morning just to hear gunshot. This is my nation, a wicked kind of nation. You wake up in the morning just to see a dead man. People die every day because of war. I wonder what to do, yet me want a better life. People suffer every day because of war. I wonder what to do, yet me want a better life. Policemen are watching, beating people, and them beating innocent people. Is it a policy or is it a remedy? To kill another man is political philosophy. Oh.
Thank you. That was Jeff Carando. Welcome everybody today to the seminar after the verdict. I'll turn it over to Isaac Okwe-Odia to welcome you here today. Isaac?
Thank you, Doctor. Thank you, viewers. Thank you, participants. My name is Mr. Okwe Isaac Odia. I work for the Justice and Reconciliation Project. I'm a Ugandan. I was born in Uganda. I grew in Uganda. And I'm serving the people of the world in Uganda. By that, let me welcome you to these very important reflections in regards to the verdict, the sentencing of Dominic Ongwen, the former leader of the Lord Resistance Army. I also welcome participants from Uganda. For those who might have not been to Uganda before, Uganda is located in Africa, East Africa. It's a land blessed with the green vegetation. The climate is good, particularly Gulu district where we are currently located. Gulu sits north of Uganda, and it is one of the districts that was heavily affected by the Lord Resistance Army. And I would also say that the Acholi sub-region has experienced one of the largest number of rebel insurgency in Uganda. And that therefore means that the people of Acholi have been greatly affected. Today in this reflection from Uganda, Gulu, we are blessed with a number of participants from various walks of life. We have representations from the cultural institution. In Africa, Uganda, Acholi community that are well-versed. The people belongs to the cultural institutions, and they pay much attention to the contributions of the cultural union in the everyday today life. And I must say the cultural institutions of Acholi has contributed and continue to contribute in peace building following what the community went through. We're also blessed with the people from civil society organizations who work tirelessly conducting research, trying to negotiate peace here and there, trying to reconcile people from the broken social fabrics of life. We are also blessed with the artists. Amidst us, we have an artist, Jeff Korondo, who contributed in peace building in Northern Uganda through music. And we are so happy to have him here. We are also blessed with the victims community, represented by those those who were abducted and they live in captivity, and those who are also affected from the IDP camps. But also we have people who are both victims in another circumstance. If you notice, the trial of Dominic Ongwen is also affecting, Dominic Ongwen is also affecting his family members. This evening, we are blessed with a participant from the family of Dominic Ongwen. I have spoken to you about the Justice and Reconciliation Project. This is an institution that came into existence in 2005, just when Uganda was going to start a negotiation with the Lord Resistance Army in Juba. JRB was founded in 2005, basically to help in contributing to peace building, justice, and accountability. And it has done a number of activities that has contributing to shape the justice processes in Uganda, including its contributions in the drafting of the National Transitional Justice Policy. JRB works to ensure that research and documentation of conflict issues is done in the interest of the victims. We also looked into mobilizing the different stakeholders to contribute in justice, accountability, and peace building, not forgetting understanding the gender dynamics during conflict and in post-conflict reconstruction. These basically describe the existence of GRP. And I'm proud to say that as the trial and the sentencing of Dominic Ongwen has come, we are happy to say that a lot of our research document, a lot of our field notes has been cited during the trial, and that can easily explain how relevant these institutions is to the community of Acholi, to the community of Northern Uganda. I welcome you to these very important reflections in regards to the trial of Dominic Ongwen. You're most welcome. I think I should move you straight to the sessions where we shall be having participants from Uganda speaking. Dr. Erin, is that fine?
Thank you. Thanks, Isaac. Maybe Kamari and I can just offer a few words before we move on. My name is Erin Baines. I'm from the School of Public Policy and Global Affairs at the University of British Columbia. Thank you, Isaac, and Justice and Reconciliation Project for hosting us today, hosting this webinar today in your good words. Today's event, After the Verdict, is also being co-hosted by the University of British Columbia, and we're streaming here live today from the unceded ancestral territory of the Musqueam people. We begin with this land acknowledgement out of respect for the Musqueam land and families who reside here and the oceans, forests, and animals that surround us. We celebrate the resistance of Indigenous people across Canada who continue to face the impacts of settler colonialism. We also recognize the ongoing and critical work of a coalition of anti-racism activists, protesters, and allies who seek justice in this current moment of global reckoning. In this way, we acknowledge that the search for justice in Uganda is shared by all persons who have been displaced and dispossessed from land, language, and culture. I make this land acknowledgement as a tradition, like I say, of recognizing respect for and who holds the land. Please feel welcome to, in the chat, enter what Indigenous land you may be calling in from or where you're calling in from. Feel free to introduce yourself. Now we have a packed agenda for you today. We have 3 moderators for this 2-session seminar. And let me introduce the 3rd monitor to you, Kamari Clark, who's a professor of criminology and social legal studies at the University of Toronto, on leave from UCLA. Kamari?
Thank you, Erin, and thank you, Isaac.
Welcome to you all. On behalf of the Transformative Memory International Network, the Uganda Justice and Reconciliation Project, as well as the Transnational Justice Project. As we know, the International Criminal Court trial chambers recently convicted Dominic Ongwen of 61 counts of crimes against humanity and war crimes committed in Northern Uganda between July 1st, 2002 and December 31st, 2005. And yesterday, May 6th, we heard and read the sentencing judgment of 25 years minus pre-sentence custody credit. Now, while the news of Dominic Ongwen's conviction has been well received by or in some constituencies and celebrated for bringing justice to victims in Northern Uganda, it has also been met with disappointment by others. For some, it was a failed opportunity to use international criminal law innovatively to address the challenges of structural inequality and the inability to take a position on child soldiers. That is the problem we're faced with when children are socialized in contexts of war. It also highlights ways that the ICC has certainly struggled to make sense of the heuristic value of cultural evidence and spiritual cosmology in the international criminal accountability process. So there are clearly some competing sides here and interesting dynamics in the response to the verdict. This public symposium will interrogate the sharp contrast that emerged between, on one hand, the demands of the norms of what's seen as universal justice, typified by the prosecution of Dominic Ongwen at the ICC, the intersection of spirituality, cultural mechanisms such as Mato Oput, and the complexity of determining the victimhood of former child soldiers who are socialized in contexts of war. Panelists will consider how the ICC, shaped by Western ideals, has uneasily intermingled with not only African cultural practices and spirituality in the pursuit of accountability and reconciliation, but also the political and economic histories that, or upon which, the war in Uganda has unfolded. While exploring some of the complexities in the prosecution of Dominic Ongwen, this public symposium will rethink the complex victimhood and perpetrator dilemmas and how this complexity is constructed by members themselves, local communities in Northern Uganda, and it certainly takes seriously the theme of that we've called the many sides of justice. We'll ponder a broader conception of international justice, which considers local constructs of justice in different sites of atrocity, while also holding in tension the role and the value of justice writ large and international justice and accountability writ large. So ultimately, our hope is that our guests here today will interrogate these many sides of justice by taking into account these deep interpolitical histories, interpersonal intimacies, the desire to remedy harm and suffering, and the complexities of culpability. And so that's our agenda for today. It's a huge one. These are big issues. They're difficult issues. But I think we have a packed agenda with a whole range of presenters who will share their thoughts honestly and with conviction, and hopefully get a conversation going, as well as with input from the audience. So on that note, welcome to you all. It's really a pleasure to be here. I'm speaking from Toronto, Canada. And I will turn it over now to Professor Baines, who will go through some of the formats and logistics for the event, and then we'll move right into the first session. Thank you.
Thanks, Kamari. Great seeing people greet us in the chat. Wonderful. We'll look forward to seeing who you are, and your reflections are coming in already. The first section, which is next, we'll be hearing from community, moderated by Isaac. We'll then have a brief musical interlude with live music from Jeff Karondo, as Isaac said, a musician in Northern Uganda who has worked for a long time on peace. And then in the second section, we'll listen to legal experts and scholars who will share their reflections based on their profession and engagements. And then we'll open up the session to have the panelists ask questions of each other, and importantly, we'll be pulling questions from the chat, audience questions to pose to the panelists. This is just a reminder that this is being recorded and the webinar will be available publicly following the seminar. I think that's it, so I will turn it back over to start the first session. Isaac, please feel free to take over.
Thank you very much, Dr. Kamari. Moving forward to the first sessions and considering the theme for this reflection, the many sides of justice. The sense-setting of Dominic Ongwen leaves us with a lot to appreciate and a lot that we still desire. Here, I'm having the presence of victim representative from Lokodi, Mr. Vincent Oyet. I also have representative from the female victims of sexual violence, Evelyn Amoy. I also have representation from a youth representative, a child born in captivity, Moses Komakech. And I also have the presence of Charles Lapolo, who is a representative from the community, the clan, the family of Dominic Ongwen. And I have the presence of the Prime Minister of Keiko Aracholi, Mr. Ambrose Ola, is here with us. I want to invite Vincent Oyet to speak to us, but briefly about Vincent Oyet. Vincent Oyet comes from Lokodi. Lokodi hosted an IDP. It was an IDP camp whereby around 2005, Lokodi was attacked by the LRA and several people were massacred. He's a victim. He has his relatives who were also killed. And as a result of initiatives to look for redress, to demand for accountability, justice, and also for reconciliation, Lokodi community members initiated with the support of JRP, associations called Lokodi Massacres Association, where Vincent Oyet is the secretary of that association. Other than that, Vincent is a teacher by profession. He's serving the community of Lokodi as a civil servant in a classroom teaching. I welcome you, Vincent. Vincent, as a share with us this evening, and as a representative of victims from Lokodi, what is the significance of this day for you? Aware that the ICC has sentenced Dominic Ongwen for the crimes committed in Lokodi and other community. What does this sentence mean to you?
All right, thank you so much, Isaac, the team from JRP, all the colleagues present in this room, plus those on outside. I'm Vincent Oyet, one of the victims who underwent a multiple abduction in hand of the LRA in Northern Uganda. As he has put it, Lokodi is gone along Patiko Road, 17 kilometers from Gulu City. Indeed, my place experienced several attacks, but the major one, which we call it the massacre, occurred in 2004, May 19th. This year we are celebrating the 17 years. Let me start from the verdicts that was stated on the 4th of February 2021. As victims of the circumstance, we welcome the verdicts, all sampling, out of the 70 counts that was alleged by Dominic Ongwen, 61 was proved to be true and Ongwen was guilty. For sure, we received this one with warm welcome, and basing on the investigation that the court did, basing on the witnesses that was produced before the court, and the name of our own people who were massacred was read in the courtroom. That was the true evidence that we participated before the court. Then, basing on the sentencings that was stated yesterday by the judges, I and other victims of the body, we followed the sentencing well, and we will come that the court made Ongwen to stay in the prison for 25 years. For sure, we have been waiting for it for several years. As I said, the massacre took place in the on the 19th of May of 2004. So as victims, since we have been waiting for it for a long time, we welcome the sentencing of Dominic Ongwen, and we are well assured that the judges also announced the process of reparation that should start off immediately. As victims, we hope that through that, we as victims, or our livelihood that has been destroyed, can be restored. Finally, I need to also appreciate Justice and Reconciliation Project for all their documentation. Indeed, their documentation since around 2010 up to today, their reports that have been shared with other civil society organizations made, and some of them, even the court, tried to prove it, and it was found reality. So I need to appreciate the Justice and Reconciliation Project for that documentation. As victims, we receive the sentence of Dominic Ongwen as it is true, and we rely on it. We don't have to dispute that statement. Thank you so much.
Thank you very much, Vincent Oyet from Olukode. Thank you so much for correcting me for the period when the massacre happened. It was in 2004, May 2019. And that is for your corrections, listeners and viewers. What I heard from you in regards to the sentencing of Dominic Ongwen, there is possibility of a court order to reparations, and you're looking at the livelihood that you people of Olukode lost during the massacre during the war probably would be restored. What are you looking into? Do you feel that an institutional reparations works best, or you think an individual kind of reparations would work best for the community of Olukode?
Thank you so much, Isaac. You know, with the issue of reparation, people have different opinions. At the beginning, people was hoping for a community reparation, whereby it covered a larger people. But you know, human demands keep on changing. So for this one, since the court has ordered for reparation, I feel that the victims should be consulted and the new idea can come out. So for now, I can't speak for that on their behalf on what to do, but I feel as a group, as an association, we need to come up with our own priority that should be revealed by the transfer through ICC.
Thank you very much, Vincent, for your deliberations. Ladies and gentlemen, I will move to the next person, and that is Evelyn Amoy. Evelyn Amoy, may I invite you to speak in these very important reflections. If I'm to introduce Evelyn Amoy, I may be laughing a lot, looking at her contributions and her background to this conflict. Evelyn Amoy is a distinguished human rights activist. She is a co-founder and the chairperson of Women Advocacy Network. This is a forum that is hosting over 900 women that advocates for justice and reparations in Northern Uganda. In 2015, she published her book with the title, I Am Evelyn Amoy, Reclaiming My Life from the Lord Resistance Army. Based on her 11 years experience of abduction, conscription, and eventual forced marriage to the leader of the Lord Resistance Army, Evelyn is respected as a mentor to other people who went through conflict. Evelyn, being a youth and a child, and currently she helps to facilitate the reunion of children that are separated from their families during the war, as well as she works towards the realizations of reparations for women survivors. This is just a drop of what I can speak about Evelyn Amoy. Evelyn Amoy is going to be supported by Dorcas so that you are all able to understand her. She's going to speak in Acholi and Dorcas will be translating her. Evelyn, you're most welcome together with the Dorcas. If I'm to direct you, Evelyn, I would ask you to look at the verdict which has just been concluded for the crimes of forced marriage and pregnancy. As a survivor of these crimes and a human rights leader, how do you view this judgment of women for sexual and gender-based violence? Is it a fair judgment? Do you have any concern?
Right, answer. Medical white look more material, my child down a car middle and any down work, pound my phone, my car will be tearing my tail, what did you do? Tiote, you don't bear a picture, Carmen of car,
I want to thank Isaac. During conflict, many people went through different violations. Young women, men, girls. Others were forced to stay with men when their age had not yet reached that time and it wasn't their interest. Others were forced to carry luggage.
Dear more better guac, I couldn't bear it, Tian couldn't bear it, in your America more again. Child duking it to my town the day for me.
Many women came back with different reproductive issues due to forced marriages, and many were conceived from captivity. And so now that they came back, they have different challenges. Others have reproductive challenges due to early pregnancy. Some have trauma.
Kada being in a gamma, kita aranel getting on Kinelna and then watching for a PNP car, my life victims of it.
According to the verdict that was made yesterday, according to me, I accept it because victims have been waiting for it for so long.
That particular penny, con my when typical Magutim Valley Wang, Kede, Karaka Diramayakin, conjures it, negative, if I could be dark on Marpian, for Jim or Polly, where we don't carry and Dominic Ongwen.
But I have a question according to the verdict that was done and and some of the atrocities that is alleged he has committed. Is all those violations that he was alleged committed, is it on it's for all the rebel commandants that did those, or it is only for Ongwen himself? Assuming Coin is also brought to court, will his his process be started afresh or to be based on what was alleged when committed?
Kibena kita na kere kita ko tuwa kere nge eni kibe lokme reparation le beti donc duana ma dirti ne reparation mo type victims mo ber gang again kede victims ma ber go ber bot LRA yan ken ner mot kita abera na kere kitung bar nen char tikem victims ma Dominic Ongwen timo bali kombe donc wan makar wo bale ni ko wan mo adu ko team mape wangeo ka kun wanyalo ki ya duki merek.
And according to the reparation that has been said, I've had the reparation is kind of targeting the victims that were violated by Ongwen, and yet there are different type of victims. There are victims that stayed in captivity and they also suffered, and now they're back home. Some of them came back with children, and children needs reintegration. There are various challenges. What will they do for these other victims that were not directly affected, maybe violated by Dominic Ongwen case? Will they be involved in the reparation or not?
The matika missing car melwen get a car make a mouth to terror Sudan. Till the tear moka ma pego o mukana dego chiro be okay yo ma pego o kwa teacher. Jo eone ma fulu nyur gitika pari wa chengtin. Ngoma ICC betimu again.
And also we have children, the children that are like children born from captivity out of rape. And then there were children that died in the process of escaping, and others did not reach home. What will ICC do for these children who are missing? The missing ones, the ones who are dead, and the ones who are back home?
Ngamo below pig, Jomadota, Kena Jomukana Mol, P. Jomukana lay your cham, put Pia or Sudan. Kidong Kitaki Berg and Wenkere, Pedong Pipone, and Bella Tiama put Mara, and Ubero Ngamu, what LRA. That they go be chill down when my room, Chidong. But I knew Mamma ICC with Timopiane, Tijomukan Maguna Wano, state by government. Ma inone karme dugune no kibot LRA or yoda government good you to the running combe mukane rep da mukane madaki rep gini yo mi dugan any ICC dwar ko wakeni ni victims madong combe pere kima
another question is the victims that died in captivity, others got drowned in water, others were eaten by wild animals. What will ICC say about that? How will they compensate them? And secondly, there are also victims in the process of coming back home. They came through, maybe they met the military, like the UPDF. Some of them were violated, maybe were raped by these soldiers. What will ICC say about that, and what will ICC do for them?
Kidong litiang madong wanwal kipilu ma genti no pero on gen pengen pengawaran wal kipilu pengen pengawaran wal kipilu era dong gitie per gedong tima dira da ke ter ge gang ge ben joma na yo gam litiang ke kete dugu ida side man kete kinero yer no mu la bole chalo ko re nyu ba lo na biage ka tell la tien mo ne kuno joma kuno benane la tien en wana be la lwen wana yo ke pere ko dar ma megwa ko le tien en wo betimo gini nyo wo be ker ka kwena.
And also based on children born from captivity, based on the reintegration process that has been implemented by one, most of these children are rejected from their own family, like paternal side. When you take them, assuming you take them to Lukode, Abia, Balonyo, some of them are treated like they're the siblings of the rebels. And so they are not accepted there, they are rejected. So what are we going to do for these children? Because they are facing a lot of challenges in the community.
And Dominic Ongwen during my return here. Don't tell but Dominic Ongwen, if a nana tell what again, Ben, Bal, get to you, Mamma ISIS you, but while you then come very chowan, make a little, I think they make a little. Mio, we give food per right to while piano, get down when I can't carry a Latin, get your car from when the better peg of a year, get you again, get peg again, and Latin for good. You don't, I see we're going to get in where don't any, and I can't. Given you are not a prayer calling the Roger getting wiggy, we have to beg of time, Mamma, we can't.
And also another question is, Dominic, when also have to give back to children, and these children are back in the communities, they're staying with their mothers, and it's their mothers taking care of them, fending for them, providing everything for them. And they also have challenges. Now that Ongwen is convicted, what will ICC do for these children? Because most of their mothers are going through traumatic processes and they need support. Will ICC take these children that as perpetrators as well or not? So how will ICC support these children?
I get a mirror for Jumago Chunket, but one Makar with JRP, maybe I chill victims. Keribeti from the Chavan and one dog, one dog, pero fun mamegi.
I also want to, lastly, I want to thank JRP for supporting us victims and standing with us through the process.
Given a car, make you a piece of then make a very chalk ever where can you water oh ye, catchel cake, quire, book on what 12 minutes. Can you what you were what cherry, oh, given what do can you hear what do we Cake alquaro, JRP, Kidom local government. Do them a papa, Margaret, and peace talk.
I also want to thank different institutions like the Kekal Kwaro, NGOs like JRP, and other institutions like local government during Juba Peace Talk. They were so supportive. They would move together with the victims and everyone that went to attend the peace talk. And so I want to appreciate them for all that they have done.
Thank you. Thank you very much, Evelyn Amoy. Evelyn has spoken like a mother. In our remarks, in our presentation, she has unearthed some of the negative impact of the LRA war. She has spoken posing a lot of questions. In my own understanding, the sentencing of Dominic Ongwen should lead to the answers of those questions that Evelyn Amoy has been posing. Questions to do with the children born in captivity. Questions to do with who is a victim. Can the children of Dominic Ongwen be part of the victim? Questions to do with those that went missing. No accountability has yet been given to. It's me and you to discuss it, to look into what could be the answers to questions that Evelyn has already posed, so that the sentencing of Dominic Ongwen is made meaningful to those that were violated during the conflict, especially the women who were sexually violated. Thank you very much, Evelyn Amoy. I would move to the next person, and that is Moses Komakej. May I invite Moses Komakej. Moses, if I'm to speak about Moses a little, Moses is a youth representative from Women Advocacy Network, where he is currently helping to facilitate the day-to-day operations, implementations of projects, working with the conflict survivors and other survivors network. As a child born in captivity, Moses is using his experience to demonstrate and channel positive energy and attitudes towards building and promoting peace. Moses is a graduate of Bachelor of Economics from Deja University. You're most welcome, Moses. And as someone who has been in the rebel captivity and live with this identity after return, Do you see the verdicts representing your experiences?
Thank you, Isaac. Thank you, everyone, today. Thank you for this opportunity. My name is Komakech Moses. As Isaac has already stated, I'm a youth representative from the Women's Advocacy Network. In regards to the verdict of, on Dominic Ongwen's trial, I want to start by highlighting the positives. There are some positives from the verdict. The positives being this verdict sends a strong message to the world, to our nation, and the entire world at large, that no acts that no acts of impunity can be tolerated in the world we are living in today. However, to me, the verdict is not so satisfying. I'm not fully satisfied with the verdict, in that it does not address the issues, the pressing issues and challenges of children born in captivity. For example, the verdict does not address the issue of education for children born in captivity. It does not address the need for medical help and assistance for children born in captivity. It does not address the issue of the quality of life of the children born in captivity. It does not address the need to belong somewhere for the children born in captivity. Many of us do not know where we come from, where our fathers come from, our paternal homes. In our culture, in our Choli culture, it's very important. You need to know your father's home. It's your home. So your maternal home is not exactly your home. So at your paternal home, that's where you have all the rights. You possess all the rights, right to learn and access to other important things in life that a child can have. The verdict did not touch those areas. It has not addressed the areas. And I'm aware, as stated from the verdict and as stated during the trial, I'm aware of a court order reparation for the victims of the case locations. But the reparation, as it was said, it doesn't touch other victims and other children born in captivity. And I want to say I really sympathize with the children of Dominic Ongwen, because they are not included in the reparation that was mentioned at the trial. Because as for me, from the way I see it, from my view, I see the reparation is directed towards the victims at those locations where the atrocities were committed. That being said, I want to say that being a child born in captivity, we as children born in captivity, we didn't wish for it to happen. We did not apply for it to happen. Our mothers were abducted, they were captured, they were taken into captivity, and they were violated sexually. And we are a result of the sexual violations that were persevered by our parents in captivity. So as an advocate, I would really be pleased and glad and I would like the court to redress the issues, the challenging issues of children born in captivity. As I mentioned earlier, this trial, this verdict sends a strong message, and it's going to help to prevent these activities, impunity, the acts of impunity from happening again in the near future. And as a child born in captivity, I want to be the last child being born as a result of such impunity acts. I do not want another child in the future, anywhere in the world or in our country, Uganda, to be born out of such acts again. Thank you so much. I don't have much to say.
Thank you very, very much, Moses. Moses' strong message, and as an advocate, is that he should be the last child to be born out of war as a result of war. I think that is a very, very strong message to all of us. If children being born as a result of conflict, as a result of war, can end with those born in the circumstance of LRA, then we shall have done the best for the world. Thank you very, very much, Moses. I would move to the next person, and that is Charles Lapolo. Charles Lapolo is a representative from the family, from the clan of Dominic Ongwen, and that is Chorom. Charles is a teacher by profession. He's a civil servant, works in one of the schools in Amuru district. You're most welcome, Charles.
Thank you.
Thank you, Charles. As a representative of Ongwen's clan, how do you see this sentencing, the convictions of the son of the soil? How does it make meaning to you?
Thank you, Isaac. I would like to say first and foremost to thank the Almighty God for allowing me to share this important reflection meeting of yesterday's sentencing. As a born of Ongwen, I'm the brother of Ongwen Dominic. The clash between UPDF and LRA in Uganda made the part of the country behind. I would like to begin by thanking the government of Uganda for considering Northern Uganda by initiating different projects to restore the people, the livelihood, those ones who suffered in the class of LRA during the insurgency. As per yesterday, Ongwen, I can say I'm not all that happy of what has been put forward yesterday. Ongwen went to the bush forcefully. He went to the bush when he was still young, being forced by LRA leader Judgement. When he was still only 9 years, I was not there. I'm a born of 1990. My father told me, my son, for us, we are in the bush. We are suffering now, as I tell you. In 1997, we were forced to come and gather in the camp. For us, we were forced to go and gather in the Bongeli IDP camp. My father told me that they don't have their brother called Ongwen. He's already in the bush. The mother of Ongwen, the father of Ongwen, was also killed by LRA. Now, the ICC would have considered that Ongwen being forced as a child, you have to be taken in a way that they can reform when to become a human being like us after the war. He was forced to do all the crimes. And now the 61 crimes is not only on Ongwen. Now he's carrying it alone. We have the like of Kony. My father also told me that Kony was acting in a spiritual way. Kony have its own kind of force. If he send you to go and do something, if you happen to fail, he will come and kill you. That made Ongwen to follow what he wants. And when he was still a young child, my father told me also, they were playing together. And the role play of Ongwen was to become a pastor or a bishop, not a soldier. Now, Kony made Ongwen to do something which is not expected out of Ongwen. Another thing is that now that by yesterday, Ongwen is going to lose the relationship with other family members. Ongwen have children, Ongwen have relatives, clan members. Others, they actually, the Uganda they have not yet seen Ongwen physically. Now that kind of relationship, if all that possible, we are praying that if the JRP can afford, they can go and talk to ICC that when have people here in Northern Uganda, they would like to see when now that they have given 25 years of imprisonment. Me as the brother, me as a clanmate, what can I do to see when physically? With all these 25 years. Another thing is that the people where he has committed the crimes, the people of Lukodi, the people of Pajule, and other places, Uganda, particularly Northern Uganda, are they going to be happy of us, the people of Ongwen, the born of Ongwen, the people of Chorom, with the people of Lukodi, Pajule, and Uganda as a whole? Will they be happy of us? They will say, the people of Chorom, particularly the Paga clan, where we are from, we are the terrorists. We are bringing children to fight in the country, yet we are not. Because all these 61 crimes, I'm not all that happy. My brother cannot do all such kind of crimes alone. Another is that I can see that there is need to do reconciliation so that Ongwen can still come back to normal life. So that the family members, me speaking, can see Ongwen physically. I can conclude because I cannot talk much. I'm not all that happy with yesterday sentencing. If I can talk, I may even cry. I'm not all that happy. But to talk last, I request people in the world, because not only Uganda, if they can consider not only people of Lukodi, Pajule, they should also consider the people of Chorom, because we are all suffered a lot. Everybody there have been abducted, others escaped. My father escaped in 1998. There was a class between LRA and UPDF in Tegot, Kila. My father happened to escape from there, called the thing. So I'm not all that happy for the happening, but we don't waste, but God knows where we are going and will direct us. Thank you, Aja.
Thank you very, very much, Charles. the sentencing of Dominic Ongwen is treated with mixed reactions from community to community, persons to persons. And that is the feeling of a brother of Dominic Ongwen. He narrated the circumstance that led Dominic Ongwen to committing those crimes. He has also spoken about relationship issues which needs to be addressed. Having these communities, the people of Chorom, the people in the case locations, and the general Uganda, how do they look at the family of Dominic Ongwen? He has talked about possibility of seeing Dominic Ongwen, even if he's going to serve his sentence for 25 years. These are some of the things that the discussions can later follow. Let me welcome Mr. Ambrose Ola. Ambrose Ola is the Prime Minister of Kekwaracholi. Kekwaracholi is an organization comprising of leaders of the different clans of Northern Uganda, of Acholi people, and promotes traditional Acholi customs and values. It played an important role in attempting to bring peace in Northern Uganda and to restore balance through traditional means. Kekwaracholi was instrumental in getting the government of Uganda to pass the Amnesty Act and played an important role in the Juba peace talk. Mr. Ambrose Ola, you're most welcome. As I invite you to speak, can you speak about the Ongwen's trial and the verdict from the cultural perspective? Thank you.
Yeah, thank you, Isaac, and thank you, everybody who is participating. First and foremost, I'm going to focus on the grand scheme of things that relate to this case. As Isaac has said, I am going to try and delink emotions from whatever I'm going to say. First and foremost, the muted response to the conviction and sentencing from the population of Acholi really highlights the dilemma as to whether they are seeing this as justice in itself. There are so many reasons that can be attributed to this, but I'll come to that a little later. The sentencing of Dominic Ongwen yesterday was expected because of the high-profile nature of the LRA war, especially in its later years, and the people of the world that it involved. And therefore, more and more people began to think they needed to find a mechanism of getting some form of accountability. And fortunately or unfortunately, Dominic Ongwen became the pawn in the whole effort to get some form of accountability or to explain the essence of this war. And that is where we come from. It therefore implies that the way the case was set up was such that Ongwen had to get the conviction and sentencing he got. To us, actually, we are left wondering, the time frame that was set from 2002 to 2005, is that adequate to get the justice that we wanted about the overall context of conflict in Northern Uganda? The geographical spans, the 4 areas that were covered, is that representative enough to define victimhood and the impact of conflict in Acholi or Northern Uganda? Because we are aware of many more places that such atrocities happened or massacres. Atiak, Lamour, we had Mutwini, we had Gergere, we had Balonyo. Gergere, in fact, people were cooked and forced to be eaten. So what it will be the sense of justice in this case for those other people in the who have been left out? The third is, I don't want to say, are the historical protocols that were there arranged to solve the problem. The amnesty law, which helped to bring back so many of the ex-LRA fighters and who have now settled and are back living and performing very useful activities within the community. So these and many other questions that the trial did not answer still leaves a lot of questions to be asked about the whole essence of justice in Northern Uganda. Now, after the sentencing, people are talking about reparations. Yes, we understand the victim fund is there, the victim something fund is there. But there are many other complementary actions that are required from different stakeholders. How will these stakeholders be brought in? Government of Uganda is there, maybe the UN, NGOs, and all this. How will these complementary actions be done? These are very, very important. How shall we deal with managing expectations? Because in this whole case, wide-ranging expectations have been brought. Many of the victims in the case are having very high expectations and are only happy because they are sure of some form of reparations. Yes, they may be able to get the reparations, but now that leaves us who deal with the broader sense of the conflict in Northern Uganda and its effects, having to contend with the questions from the rest of our population. What about us? The people of Atiak will ask, what about us? The people of Lamoa will ask, what about us? The people of Mutwini will ask, what about us? Now, whose responsibility will it be to answer those questions? The case also narrows down the definition of victims. It narrows down the definition of victims and victimhood. So these are some of the key things that we find very problematic. So much has been said. Now, if you are going to look at the broad context of these atrocities, can they be solely attributed to Dominic Ongwen? Because then we begin to narrow down the effects of these atrocities to think that by convicting Dominic Ongwen, the justice has been secured. The case did not consider a very important aspect of justice in Acholi, and that is divine justice. You cannot say traditional justice, which transcends human human conception to divine conception, is invalid in this case. A lot of explanations are drawn into the spiritual realms of this conflict. In Acholi, to get final accountability, there must be divine justice sought. There should be a sequence of rituals performed. That is when people feel relieved. Even the victims today who say they are victims, traditionally, they will never remain settled even if they're compensated, if they don't undergo certain rites and rituals. Even on when, if he as it said, he is actually sentenced, or when still has to go through these divine just processes of justice. So saying these traditional justice mechanisms do not matter, leave a lot, and yet traditional justice has been responsible for the calm, the reconciliation, the resettlement of the broad section of and the thousands of ex-LRA who have come back and are living and are maintaining are maintaining a normal life within the communities, and the communities have truly accepted them. Finally, sorry, you have heard, was Dominic Ongwen responsible for the war that was fought in Northern Uganda? I believe he even doesn't know why the war was fought. Because by the time the war started, Dominic Ongwen was hardly a year old. In 1986 or so, or something of the sort. I think he was still a young boy, a young kid. So who do we apportion responsibility? Somebody has asked, what about the LRA? Then there are crimes that were committed not by the LRA. That still constitute crimes against the people of Northern Uganda. The Namukora massacres, the Acholibu massacres, the Buchor massacres. How shall we answer for this? Therefore, we think the Dominic Ongwen case is a very small microcosm of what constitutes justice for the people of Northern Uganda and for the people of Acholi. I thank you.
Thank you very, very much, the Prime Minister, Mr. Ambrose Ola, for what you have spoken. Mr. Ola emphasized so much the complementarity aspect in regards to the verdict, in regards to the sentencing of Dominic Ongwen. He made mention of the government of Uganda, the UN, the NGOs, including the cultural institutions. Charles talked about relationship issues. His emphasis is how do we deal with some of these issues outside the courtroom so that there is coexistence, basically, in the community. Thank you very much, Mr. Ola. I want to invite Jeff Korondo for an interlude. As I invite Jeff Korondo, Dr. Erin, I believe that is still fine. Thank you. I want to invite Jeff Korondo, and if I'm to speak a little about Jeff Korondo, his introductions helps us to understand the role of the different stakeholders in peace building in Northern Uganda. Jeff Korondo is commonly known as, his rightful name is Geoffrey K. Opiu, AKA Jeff Korondo is a stage name. Jeff is a musician and a community peace builder who has produced and performed songs with peace messages from community sensitization for over 15 years. Jeff Korondo is a co-founder of Music for Peace, a community-based organization that
perhaps as Isaac, we wait for him to unfreeze, or your mic went off. There we go.
Thank you. Music for Peace is a community-based organization that promotes the power of music for positive social change. He's among one of those most recognized musicians in Northern Uganda, whose music has contributed immensely in the peace building and post-conflict recovery process in Northern Uganda. I welcome you, Jeff.
Yes. Hello, everyone. My name is Jeff Korondo, as stated by Isaac. And
I am a musician. For the last coming to 20 years plus now, I think, we've been singing a lot of songs for peace building. And most of the songs were lamentations. We were just crying out because in our heart, we are also very hurt. And most of us who come from Northern Uganda, we are victims one way or the other. I was meant to do a song that talks about lo global, which means issues of this world. But upon listening to all the conversations and opinions, I have decided I need to do another song that is called Okwera Nono, which means you are rejecting me for nothing. It talks about rejection of formerly abducted children, former victims who returned home, not knowing where the land boundary is, or some other people who are in captivity, or maybe some other people who lived in the town or in the IDP camps. Then upon returning home, they don't have where to go, and the community also rejects them. So it calls upon all stakeholders, from religious leaders to cultural leaders to other opinion leaders, to arbitrate, to help and guide the young people so that we reconcile as a community. Thank you.
Thank you.
Thank you so much, Jeff Carando. It's always such a pleasure to hear you play and to hear the many narratives of the war through your music. In this, we're moving now into our second session, which will be moderated by myself and Kamari Clark. And we'll be considering some of the legal, moral, and living senses of justice and reparation following the sentencing. I'll do the same format as Isaac. I'll introduce the panelists and then invite questions, and we'll continue in that vein. So we'll begin with Judge Ben Gumpert, QC. Ben, are you there? As well as Beth
Yes.
Lyons. Oh, great. Hi, Ben. As well as Beth Lyons. Ben is currently a circuit judge based in Woolwich Crown Court, London, UK. He was previously a senior trial lawyer at the International Criminal Court and led the prosecution team in the case against Dominic Ongwen up until his appointment as a circuit judge on May 25th, 2020. Beth Lyons is a defense counsel in the Ongwen case at the ICC. She has also defended clients at the International Criminal Tribunal for Rwanda, where she and the lead counsel chief, Charles A. Taku, won an acquittal on an appeal for Major FX Nziwane Meyeye in Prosecutor versus Ndin Dili Yamanen. Previously, she worked as a legal aid criminal defense and appeals attorney in New York City and has since served as an alternate representative to the UN for the International Association of Democratic Lawyers. Welcome, Ben and Beth. Can I begin by inviting each of you, please, to offer a reflection on the sentencing yesterday in relation to the penalty that was imposed by the judges. We're especially interested in your thoughts based on your experiences as members of the defense and prosecution teams. And perhaps as you're reflecting on that from the positions you come from, you could also invite you to share any responses to the previous panel's participants. So could I invite you, Beth, would you like to go first?
No, no court rules, but I would ask that Ben go first. He's smiling.
I always love to mix things up and inverse things, but you were quite right. Ben, let's go first, please.
Sorry, Ben.
Well, before I start, I want to add a little bit to what you said when you introduced me, Erin. It's true that in the Ongwen case, I led the prosecution team. For 5 years in the first decade of this millennium, Beth and I worked together as defense lawyers at the ICTR. And of course, now I'm a judge. So I'm not going to speak solely from the perspective of a prosecutor. That's not my profession. I'm an advocate. And I expect and hope that all advocates take a dispassionate view. They defend or prosecute cases according to their instructions. But they're not, or shouldn't be, in my opinion, emotionally engaged or one-sided in the work that they do. My reflection on the sentencing is that 25 years in prison is a very, very long time. And for a man who was abducted as a child, somewhere between the ages of 10 and 14, and who himself underwent the atrocious experiences which Beth and I heard about over the years that the evidence was given, it is a very long sentence of imprisonment. And I think that the judges wrestled with the very strong mitigation which his own victimhood represented. And Judge Schmidt, in his speech yesterday morning, made it plain that that had been a very difficult task. But of course, set in the balance against that is the fact that by the time the crimes which he was sentenced for yesterday were committed, Dominic Ongwen was a grown man, and on the basis of the judge's verdict and the evidence that they heard, a man in control of his own faculties, and a man who was not under effective duress, who had had many opportunities to escape, and who approached his work as an LRA commander, attacking civilians in IDP camps with ruthless vigor, so that hundreds died and many more hundreds, mostly children, were abducted and forced themselves to become child soldiers, victims of rape, and sex slaves. I'm not going to give an opinion on where the sentence should properly have fallen and whether the judges got it right or wrong. But they were wrestling with very large concepts of wrongdoing and mitigation. It was plain that they were going to have to pass a significant custodial sentence. And in the end, they drew the balance where they did. Right or wrong, I think it would be hard for anybody to say either that they approached their task unreasonably or in anything other than the very best of faith.
Thank you. Beth?
Thank you very much, and I want to thank the organizers for this very important symposium. Following up on Ben's remarks, I don't have an opinion about the individual judge's intent or what they were wrestling with individually. I don't know that. I can't speculate. But looking at the judgment, there are certain things that are very, very clear to me. First, I would like to set the context. Many people on this in this symposium probably watched the judgment yesterday. I watched it it was 4 a.m. at my time, 5 a.m. What was apparent to me was that this rendering of the sentence on the verdict was basically business as usual. Standing before the court was a defendant who was convicted, who has not had access to almost any pages in the 1,077-page judgment on which he was sentenced. To me, this is a travesty. I don't have time to go into litigation that the defense has undertaken in terms of the right of translation, et cetera, and fair trial rights. But that's what I saw. And it seems to me this is wrong. It's wrong whether it happens in a national court or whether it happens especially in an international court. But the court was determined to sentence him, as I say, business as usual. Secondly, as everyone knows, Mr. Ongwen is a mentally disabled defendant. Even if he had been given all of the full translation, which he hasn't, he has maybe a few pages, that's it. He needs extra time, extra resources to take account and to accommodate his mental disability in reviewing the material and then being able to instruct his counsel. He was denied that right. Somehow my legal gut says to me that if the situation were different and we were dealing with a white European defendant who had a language issue, things would have happened differently. There would have been some difference in procedure. Something would have been different. But yet yesterday we're faced with a sentence that was given out to someone who didn't speak one of the two working languages of the courts. We were faced yesterday with a person who was sentenced who has a history, the court has a history of not respecting and accommodating his mental disability. This to me also sends a bad message to potential defendants. I mean, what does yesterday's sentence say to the thousands of child soldiers still out there, right? Remember, Mr. Ongwen surrendered. What does it say to the thousands of child soldiers out there about the duties of the, quote, international community, as well as the states, in this case, Uganda, to protect and to support child soldiers? And lastly, what I think is important about the sentence is the court kept saying that it considered the Acholi culture and resolution, dispute resolution within that culture in Mato Oput. But in fact, it's my opinion that objectively that did not happen. The reason I'm saying that is that the argument the court made for rejecting the defense proposal that if there were a sentence that Mr. Ongwen be released back to the community to undergo traditional Acholi practices, the reason I'm saying that is there was no evidence, at least in the judgment as I've read it, to say that the court really took the time to investigate, figure out, does it have the power to, first of all, be a little bit creative in the sentencing, and does it have the power to look at these issues? I think that Isaac and maybe one or two others talked about complementarity. I know that I had this discussion for a few minutes with Miss Abigail Bridgman, who is an attorney on our team who's in the participants. Complementarity has historically been dealt with, you know, in the ICC proceedings as investigate and prosecute. But what people are raising is, doesn't complementarity also apply to the issue of sentence? That's the case, that's the issue that's raised by the Ongwen case. So I basically feel that the message that was sent was wrong and negative. Lastly, I want to say that our position is that, and I know it's been rejected by the court in the judgment, but our position is that Mr. Ongwen is a victim today, was a victim years ago when he was forcibly abducted, 1987, and will be a victim tomorrow. And I think this discussion about when does victimhood end, or does it even end at 18? Our position is, of course, no, it doesn't, right? So I think that this needs to be discussed and this needs to be dealt with, both in the international legal community, but also within the Ugandan community as well, and in Northern Uganda. Lastly, what I want to say is that I think the sentence is a negative mark on international justice, because it shows to me that international justice does not have the flexibility to understand where its processes begin and end, what its strengths and limitations are vis-a-vis whatever the local traditional process is. And I think that this was a question that was raised by one of our witnesses, Professor Tateka, who was our expert on spiritualism, in an op-ed to the Washington Post. And he asked, to what extent is the ICC equipped to judge a defendant like Ongwen, for whom metaphysical experiences are key to motivation and actions? And I think the court has failed. To me, the judgment and the sentence exposes failures. It exposes failures in international justice and rule of law. A few of the speakers in the last panel talked about some of the crimes that were committed that weren't addressed, particularly by the UPDF, and also, I would add, by the government of Uganda in forcibly moving people into IDP camps. Now, I think that what we also saw in the judgment and sentence was clearly selective prosecution. Now, I've seen this before at ICTR, which only investigated and prosecuted the Hutus who were involved in the 1994 events. All 93 persons indicted were Hutu. No one was a Tutsi. This was selective prosecution. I see it again here in the judgment and sentence and the functioning of the ICC. So I'm happy to comment more on that later, but I just want to present that because I think that context is important in terms of looking at the judgment and sentence and what it means, both in Northern Uganda, but also to those of us who are outside of Northern Uganda and part of this greater international community. Thank you.
Thanks so much, Beth. I think you so well laid out and responded to Judge Gumpert's position that the judges, we can't really know how they arrived at their decision, and especially the mitigating circumstances. And you laid out well both perhaps the limitations of the judges to interpret the full case, but also with what evidence they had before us, what a struggle that must have been to arrive at that decision. We do have to move on to other panelists, but before we did, could I go back to Judge Ben and ask if you have anything further to add, given what Beth has said here?
Well, her comments were pretty wide-ranging. If I was to begin to give my responses to them, I'd take up far more time than I suspect that you will allow me. I think it's a pretty astonishing and grave allegation to say that the court has denied Dominic Ongwen justice on grounds that he was a black man, which is what Beth has just said. I don't think there's any evidence of that, and I think it's a slur which is not merited.
Okay, thank you. I think we will move on now to our next panelist, Kamari.
Yeah. Okay.
And,
thank you. Thank you, Erin, and of course to Ben and Beth. And it almost feels wrong to transition from that intervention in many ways, the idea that the relevance of race and how we think about race and Blackness, coloniality, post-coloniality in the case of Uganda, and some of the political and very real historical context in which there was violence and a war in Uganda. So that is something that we can circle back to. I think it's relevant. How do we think about race? What is the relevance of language, if at all? What are the procedural issues where that's concerned? So we'll see if we can swing back to that question, because it's not unimportant, but I think that there is some precision that we need through which we think about the relevance of race in international law. So certainly I hope we can tag that again. But now let me move on to the next two panelists. We have a total of 3 left who haven't spoken, so I'll introduce the next two. The first of the two is Dr. Ayodele Akinroye. He's a postdoctoral fellow at the Center for Criminology and Socio-Legal Studies at the University of Toronto. And previously, he was a visiting professional with the prosecution division of the ICC and assigned to the team prosecuting Dominic Ongwen at the time. And he, of course, is now based in Toronto. He has experience practicing criminal defense law in Canada and also serves as a judge in Canada. So welcome, Ayo. And the next person I want to introduce before I turn to questions to both of them is Ketty Anyenko. Ketty is a PhD candidate in interdisciplinary studies at the University of British Columbia in Canada. She has 12 years experience conducting peace building, transitional justice relief, and development program planning and implementation at grassroots, national and international levels. Her doctoral research area is on sexual violence and transitional justice. So welcome to you both. So my first question to you, I'll start with you, Ayo, is what did you think about the judgment yesterday, of course? What are your initial reflections? And then that from there, I wonder if you can also reflect with us on this victim-perpetrator dyad. Clearly, this is a theme that has come out over the course of today, over the course of this session. And there are larger questions about the fact that while Ongwen was legally found guilty, what about the moral judgment? What do we make of that? So if you could start by some reflections on the judgment yesterday, and then if you could just tease out a bit more this problematic around victim-perpetrator dyad, the problems around it. What do the categories mean? Where do we go from here? Thank you, Ayo. You're on mute. Could you unmute? We can't hear you, Ayo. Could you try again? Okay, while Ayo is...
Can you hear me now?
Yes, we can hear you now. Thank you.
Sorry about that. So I said, thanks, Kamari, for inviting me. And before I start, let me just say that I'm really surprised about Ben's comment and reflection, particularly about the adequacy of the 25 years that was handed over to Dominic, and where he considered, and he said that it was it's really excessive, and I actually agree with him on that. But let's go back to the decision from the ICC. We see that there's an ever-present dilemma in the international criminal justice project on how to integrate other legal systems outside of the dominant civil and common law traditions. And this was a dilemma that came up in Dominic's case. In the decision from the conviction decision, sentencing decision, it was apparent that the trial chambers actually struggled to convincingly engage with the possibility of an alternative African traditional justice system, as eloquently spoken to by the Prime Minister during this first part of this session, or of this webinar rather, and also as canvassed by the defense team vigorously in their submission. But what we see is where the ICC resorted to what they call what the victims want. And that I have some concerns about around it, because I think that the currency of victims, particularly in the context of Dominic Ongwen, should not be the sole determinative medium to interrogate the efficacy or not of the African traditional justice system, as we know clearly from what we have seen from us different speakers today, that victims group in Northern Uganda are extremely polarized on if prosecuting Dominic will actually bring meaningful justice to them. that is another discussion which I can go into later on. So for me, I think it was very problematic for the court to proceed with the argument that the victims of Dominic Ongwen heinous crimes want them to apply only the legal framework in the Rome Statute in sentencing. And this, to me, throws up this critical question: which victims are you talking about? Is it the one before the court represented by the legal representative, or the ones who were not represented by the legal representative, and who were nevertheless victims of Dominic Ongwen's crime? And also, we all know that there's no uniformity of victims in Northern Uganda when we talk about Dominic Ongwen. In my own opinion, thinking forward, is that I see the ICC as a melting pot for different legal traditions, and the court should have creatively engaged with the Mato Oput tradition instead of completely rejecting it and what I would call hiding under the argument that victims in Northern Uganda do not favor it, or that the national legal framework in Uganda does not recognize Mato Oput, particularly where we know that most national legal systems in Africa were heavily influenced by either the civil law tradition or the common law tradition, or any hybrid one. Again, no thanks to colonialism, which I think Beth was touching when she was speaking. She was laying, when she was talking about the racial dynamics, which I'm not going to talk about right now. Despite that, the African system of justice and indigenous way of thinking that does not have the trappings of colonialism still exist, and as articulated by the Prime Minister again, and should be embraced instead of being demonized or excluded by the court. And that's what I saw from a careful reading of that sentencing decision from the ICC. So also, again, it's also, again, buttressing that, before I go to my next point, is that it's important to point out that if you go back to the history of negotiation of the Rome Statute, African arguments and conception of justice were largely excluded in that negotiating process. But I think, thinking carefully, that there's room within the statutes for Rome Statute for incorporating African values and African traditional form of justice. And it is very imperative for the future development of the ICC that the court hear the message of Article 21(1)(c) and integrate the general principle of law derived by the courts from national legal system of the world, which I will emphasize here also include African indigenous legal tradition. Second, the court struggled, as everyone has said during this hearing, during this webinar, with the complexity of Dominic as a victim. On one hand, the court actually acknowledged that he was captured as a 9-year-old, but immediately glossed over the impact of captivity on him between the age of 9 and the age of accountability, 8 years. I listened to the sentencing submission by Dominic himself, and he gave graphic and chilling testimony why he said he was made to kill people, drank human blood, and committed other inhumane acts at that tender age. And for those in North America, I want us to put it situated very well, and I keep situating it in any discussion I do. He was 9 years old. He was a grade 4 student that was going to school, and he was adopted. He experienced trauma, and despite that, what did the court say? We don't believe you are damaged. We believe immediately you turn 18, you have the agency to decide what is morally right from what is morally wrong, including, if you read the judgment carefully, said, including not escaping like other abductees. Thinking carefully about this, I think the trial chambers advanced the same ideas, that it will negate the very nature and purpose of international criminal justice if an international tribunal or court like ICC should declare Dominic or an individual not guilty of heinous international crime because of mental illness. And again, Beth was talking about that in our own intervention today. What I think here is that there's a body of evidence and scholarly work before the court that actually indicates that Dominic was damaged and cannot be mentally unaffected. Yet, from the careful reading of the decision, the court ignored those extensive work and finding, and rather actually declared that Dominic was a methodological commander with full mental capacity in place, and that the trauma he suffered when he was captured as a 9-year-old, did not lead to a mental disease and therefore had no lasting consequences on him. I couldn't understand that area of that. The failure of the court here to seriously engage with this complexity, particularly learning from domestic criminal jurisdictions in the way they have dealt with the impact of trauma and set appropriate parameters for dealing with the phenomenon of child soldiers, in my own opinion, actually expose other child soldiers and children born in captivity who in turn commit heinous crime to international criminal accountability without appropriately defined criteria. And I think it's a missed opportunity. Finally, I think the also area that I struggle with is the area of rehabilitation, which to me, I think is part of the sentencing principles at the ICC, not just deterrence or denunciation. And I actually think, thinking through that decision when I was reading it, that it was when dealing with people like Dominic Ongwen, rehabilitation should be seriously considered alongside with deterrence and denunciation. And here the court did not meaningfully engage with that intricate issues and of rehabilitation for Dominic Ongwen in the sentencing decision. And here you find that the court reiterated again the deep conviction in international criminal law that the most important sentencing principle are deterrence and denunciation. To me, it's also a missed opportunity. You know, and like every other person has said, there was an urgent need for the ICC to apply creative lens in dealing with Dominic Ongwen as a poster child for child soldiers who are currently in captivity in Northern Uganda, in other sites outside of Africa, even in Africa and outside of Africa, and who are all children born in captivity and who might commit heinous crime. But I think the court took the easy way out, in my own opinion. That would be my reflection so far, Kamari.
Thank you so much, Ayo. Really important thoughts on how the court has, in fact, or what the court has said in relation to the impact of trauma between 9 and 18, and what that means in relation to the absence of or possibilities for innovation in international law. So yet another tension and important set of considerations for us to move forward. I wanted to also ask Ketty now to join us.
Kamari, just before you do,
okay.
I want to correct something which Ayo said, almost the first thing he said. I didn't say the sentence was excessive. I don't say it's excessive. I said it was very long, but he misquoted me.
Okay, so the sentence was long, but that you had no objection to the 25 years. So that...
I said I wasn't going to comment on whether the length was appropriate. I just think that for a person who has suffered in the way that he has, it is a very long sentence. Maybe it is merited, but Ayo misquoted me and I wanted to put that right.
That's terrific. Okay, thank you. So noted for the record. Thank you. So let's move to Ketty now. So Ketty, could you share your thoughts with us about the sentencing decision in relation to the penalty imposed by the judges yesterday? Do you think that the 25 years is a long time? Do you think it's appropriate? What are your thoughts there? And then a follow-up question, if you could also answer this as part of your response. If you could tell us something about, in relation to your response, how you have come to understand this notion of justice then. Is justice, what is it? Is it a living thing? What difference does a verdict make in people's lives or in people's everyday life in relation to justice? So if you could start first with your reflections on the sentencing decision. Is 25 years appropriate? Is it a long time? What do you think about that? And how does your response to that connect to what justice means for you? You're welcome.
Thank you very much, Kamari. Thank you very much, everyone. Can you hear me okay?
Yes, we can hear you fine, thanks.
All right, so as a woman who was born, raised, schooled, and worked during the war in Northern Uganda. I relate to both sides of the case. But I want to note that it actually depends on which side of the coin one decides to look at and what justice really means for the war affected. This is a case that is really too complicated to make sense of without considering all sides of the coin, the victims and the perpetrators. On one hand, we have Ongwen's victims that very much deserve justice. But it also again depends on what justice really means to them, as you've heard from the various speakers that have already said this. Viewing justice from the side of the victims, like Ongwen's victims, it is so hard to admit or even recognize or accept Ongwen's victimhood, because the impact of the war continues to date in these people's lives. People are living in poverty to the point that seeing Ongwen wear a suit in the courts can make someone feel upset. People are raising children born out as a result of sexual violence and various crimes during the war, which Ongwen was part of. All these, whether Ongwen was directly the father of these kids or indirectly, all these consequences of the war continue in the lives of the victims. That is this side of the coin. And it's so hard to acknowledge that Ongwen is a victim. On the other hand, Ongwen's victimhood and suffering remain significant as well. And I relate to that as a person who was there during the war, who lived through the war and saw it with my own eyes. And I think this is my personal opinion, the court's sentencing of 25 years for Ongwen to me seems a lot. Although I have also heard that there were arguments that it should have been a life imprisonment, but the court considered 25 years as a form of acknowledging his victimhood. But I think that is not enough. It is not adequate. I see that the court tried its best to kind of sit in between that side of the coin, that thin layer between, to try and deliver justice to the victims. That is, if it meets what justice means to the victims, but on the other hand as well, to consider some level of Ongwen's victimization. I like what Beth said earlier on, that victimhood does not end. I agree with that. I don't think it ends. Once you're wounded, you are wounded. One of the women once told me that, one of the women advisor, formerly abducted, once told me that unless you were really there inside the LRA, inside captivity, you will never understand the level of lies, the level of brainwashing and manipulation that children go through. And I just want to leave that statement there. So while this sentence serves as deterrence for future crimes and recognizes the suffering of victims, what was the cost to come to this decision? I reportedly heard that the court employs nearly 1,000 staffs, and it operates on about $180 million budget per year. Did it have to cost this much to sentence one man, while his victims live in poverty in Northern Uganda, others on $1 a day? What about the state responsibility? I mean, people have already spoken about all this and I do not want to repeat, but what about homegrown systems of justice, as the Prime Minister of Kekwaro spoke about earlier on? To what degree did the case meet victims' expectations? Is Ongwen the LRA? I read in somewhere in the sentence that Ongwen designed and implemented forced marriage. I'm not sure if Ongwen was abducted as a child, but how could a child soldier design a forced marriage policy within the LRA? Research shows that both women and men see themselves as victims of the high command of Joseph Kony, the leader of the LRA, because they systematically designed forced marriage as a policy to use inside the LRA. But it's interesting to see how it's written, in the sentence that Ongwen designed it and implemented it. But I just wanted to note that researchers found that both victims and perpetrators of forced marriage actually see themselves as victims of the high command. Moving on to the second question, Kamari, about how I look at justice. So my research, it's my doctoral research that focuses on women's senses of justice and reparations. It's funded by the Vanier Canada Global Scholarship. I would like to mention that it was supported by the Women Advocacy Network. Evelyn Amoy and Moses, who spoke here, were participants, not really participants, my research supporter on the ground. And Erin Baines and Dr. Cheryl Lightfoot and Dr. Pilar are my supervisory committee members. So I worked with about 68 participants, 59 women and 9 key informants who were involved on these issues in the ground in Gulu district. But the way I analyze this research is based on a lifetime of experience, as I mentioned, and nearly 20 years of work with war-affected communities in Northern Uganda, even when my bio does say 12 years, but I've been working in Northern Uganda for nearly 20 years now. I read in the, I think it's called a request for the trust fund for victims, the parties and the registry to make submissions for reparations by September 6, 2021. These submissions may be informed by my research on women's senses of justice and reparations. In this research, I argue that justice is lived in the everyday. It is relational and it is holistic. And it's been clearly stated that types of reparations have not yet been decided by the court. And perhaps this is timely, although I want to state that my research specifically spoke to women who were abducted inside the LRA and returned. So a sense of justice as lived has 4 intersecting themes. I'm not sure I'm going to have enough time to go through all this, but I will touch on them very briefly, and hopefully we can get to them during the question and answer. The first theme is place-based justice, which precisely centers around land. The women who participated in the study asked to be given land because they need places to live with their children born in rebel captivity. Because land is home, land is a source of livelihoods, land is a place to belong. This, Moses and Evelyn spoke about identity of these children and places to belong earlier on. Land has been a key theme in this justice. The second theme is compensation. Compensation, the women argued that they want to be compensated for the time lost in abduction. They want to be compensated, as they often said it, if I'm to say it in Luo, or for the suffering that we endured in the war. Note that the women are not asking to be compensated for rape, for forced marriage, or for sexual violence. They are asking to be compensated for suffering. They're asking to be compensated for lost dreams, dreams of wanting to become a doctor or to be like any of us who are seated right here. This way of framing and asking for compensation, in my view, recognizes that women do not want to be labeled as rape victims because it causes more trauma. And also it affects the children that are born as a result of this. So such compensation schemes need to be designed very carefully without necessarily specific labels to rape. And they've spoken about this compensation to be something like monetary, a pension-like kind of payment, or something tangible like land. The third theme of lived justice is what I call needs-based. Women ask for permanent housing, permanent and durable housing, where they can live with their children born out of sexual violence and forced marriage, or SGBV, if we can frame it that way. They want education for their children. Moses spoke about this earlier on. They want medical. I feel like what Moses and Evelyn and the previous speaker from Northern Uganda spoke about pretty much are the same things that the women highlighted in this research. They want employment. They want to have salary. They want to have income to be able to raise their families. Enhanced ability to live lives of dignity in the everyday is what justice is. And that's what I framed needs-based justice. The fourth element, do I still have a minute or so, Kamari, to just kind of go through the last element?
Yeah, the last one, that would be fine. A minute is perfect. Thank you.
Oh, okay, thank you. So relationship-based justice is the other theme of lived justice. All the speakers from Northern Uganda have spoken to this, including the brother of Ongwen. Well, in the views of the women, they want their innocence to be recognized or their victimhood to be recognized because they were abducted as children. They feel that they're being blamed for the war. They're being stigmatized and their children are being blamed. They want their victimhood or their innocence to be recognized. As they often say, we were just abducted. They want a public apology from the government of Uganda, a recognition of the government's failures to protect them from being abducted. They want that acknowledgement as a sense of justice. They also want total acceptance and peaceful coexistence with their families, with their communities, with the government representatives, with everyone generally around them. They feel ignored. They feel that they don't belong anywhere. It is a sense of justice that is very relational. They want to peacefully coexist with everyone around them. That's what I call relationship-based justice. To conclude, participants did not draw the line between justice and reparations. Often questions about what does justice mean to you, what does reparations mean to you, generated the same responses. Sense of justice as lived in the everyday complements any justice process, including the ICC, including traditional justice processes, and what is currently happening in Uganda as well with regards to justice. Lived justice is applicable to any injustices or conflict situations beyond sexual and gender-based violence. And I believe even the victims of other crimes, whether it is massacres, survivors, and so on, would relate to some of these senses of justice as well. Lived justice is holistic, as you noted. If you notice, all these four themes cover different aspects of everyday lives. It is holistic, it is relational, and it is lived in the everyday. Thank you so much for listening to me.
Terrific. Thank you, Ketty. You've really given us a framework, a productive framework to think through. So people's senses of justice as lived. Of course, the contrast with the amount of money spent on international criminal justice at large, and then in particular in relation to just the Ongwen case, is at least worth pondering alongside some of the things that are needed by way of achieving justice in these other contexts. So these are very important for us to think about as we move forward and consider what kind of world of justice do we envision? Is the international justice experiment actually the way to go when set alongside some of the post-violence demands, post-war demands that people are making as they try to regroup and resettle their lives? So certainly worth thinking through. So let me just turn it over to Erin now to introduce our final panelist and to return to the panel conversation. Thank you.
Thank you, Kamari. Our final panelist is Anushka Semi, who is a Kenyan lawyer and member of the external team of lawyers representing the number I have here is 2,564 victims who had participated in the case of Dominic Ongwen. Anushka,
yes.
Are you there? Yes.
Yes.
Hi. Hi, nice to see you. I'm wondering if you could begin by sharing your thoughts on the sentencing decision in relation to the penalty imposed by the judges yesterday, and what this means in relation to the case victims that you have been working with based on your interpretation of and how you have learned from them over the years about what they are.
Hi, sorry, Erin, you just cut off at the last sentence. I didn't quite catch that.
Sure, your interpretation of the sentence and what it might mean in relation to the case victims you have been working with.
Right. So as Vincent had mentioned, I just at the outset, I wanted to say that my comments are based on consultations that our team in Uganda has held with victims during the course of the proceedings, and most recently this year in relation to the judgment and the sentencing decision that was undertaken yesterday. So as Vincent had mentioned, victims have waited almost 17 years for some form of accountability for the crimes that took place in 2004. So they've overwhelmingly welcomed Dominic Ongwen's conviction as a vindication of the harm that they suffered during that time. Regarding the sentence, as you may have followed the sentencing proceedings, the majority of victims that we consulted actually favored a life sentence for Mr. Ongwen. So there is a level of disappointment within the victim community regarding the fact that Dominic was sentenced to 25 years of imprisonment yesterday. According to victims, the gravity of the crimes, which included murder, sexual and gender-based crimes such as forced pregnancy and forced enslavement, and the abduction of children warranted a correspondingly severe sentence. In our clients' views, victims believe that a high sentence could act as a deterrent to those contemplating similar crimes to those committed by Mr. Ongwen. Furthermore, there remain real fears within the victim community that Mr. Ongwen's return to the community after serving his sentence would result in instability or have a destabilizing effect within those communities. They also expressed to us fear of reprisals from Mr. Ongwen and their fears of his potential return to the LRA. A lot of you have mentioned the applicability of traditional justice mechanisms in this case. From the perspective of victims, traditional justice mechanisms such as Mato Oput, which has been mentioned several times during this webinar, victims communicated to us that this was not applicable in this case. One of the key preconditions for this type of reconciliation mechanism to take place was an admission of guilt and an apology from Dominic Ongwen, which they said was not forthcoming. So in their view, this was not basically something that they could consider. Secondly, we also had some victims state that this process doesn't apply to mass atrocities and crimes. It usually takes place on a one-on-one basis, for a single crime. And lastly, we have to also bear in mind that the victims are not a monolithic group. They are not all from the Acholi ethnicity. We have victims who are Teso or Langi. So in their context, we couldn't impose an Acholi reconciliation mechanism upon them. The other issue they also raised was the fact that they weren't consulted on the possibility of Mato Oput and felt that they didn't want to be forced to engage in a reconciliation mechanism without any consultation. And so although victims have welcomed the judgment, it's also important to note that the concept of justice for victims doesn't merely equate to prosecutions, but also encompasses economic justice, where victims are able to live a dignified life and be insulated from further human rights violations and violence. So victims continue to articulate their demands for security and the fulfillment of their basic needs as one of the necessary components of justice. Thanks.
Thank you so much, Anushka. We heard a lot about the complexity of victimhood throughout the session today, and some assertions that some groups of victims may be recognized over others. And this gets connected to questions as well of who was represented before the court and who will receive reparations. I wondered if you could share any further reflections on how the court decided to recognize these particular groups of victims who you also talked about as not a monolithic group, but were there moments where lines were drawn between who would be recognized and not, and what complications that leaves for reparation?
Sure. So under the rules of the Rome Statute, victims can only participate in proceedings if they meet certain conditions, and essentially they have to fall within the parameters of the case presented by the prosecution. So for purposes of reparations, victims would have to be victims of one of the crimes that Dominic Ongwen has been convicted of in the judgment, and also they have to fall within the territorial and temporal parameters of the case presented by the prosecution. So there is a chance that a large number of victims won't meet those specific criteria and will not be able to participate in reparations proceedings. This is a problem you see across all ICC cases, is this distinction between case victims and situation victims, which can lead to tensions within communities, especially if the temporal parameters are very narrow and someone sort of missed out on being a victim because their victimization occurred on a different date than when the charges were brought forward. So it's a very complicated question in terms of how to reconcile these tensions between victim communities. And one of the ways, of course, that the court has considered in the past is having communal reparations or community projects that would allow a larger number of victims to participate or to benefit from reparations projects, save for those who were, accepted to participate in the proceedings. But I think Evelyn had a couple of questions about direct victims of Dominic Ongwen and indirect victims, but essentially victims can apply for reparations. They don't have to directly have been harmed by Dominic Ongwen. They just have to have suffered from crimes under which he was convicted for. So that's something to bear in mind. And also for deceased victims, a family member can apply on their behalf. So that is also a possibility going forward in terms of reparations. But as mentioned by others, the chamber issued an order on reparations yesterday, which orders the registry and the legal representatives for victims to carry out a mapping of victims that will be eligible for reparations. So that right now is I think the way forward in terms of ensuring that victims have sufficient outreach about whether they can apply for reparations or not, and what the exact parameters would be that would make them eligible for reparations.
Thank you, Anushka, for bringing out those finer details and challenges. Much appreciated. We are nearing the end of our 2.5-hour symposium. We're really thrilled at the diversity of our panelists here today and the richness of it. We do want to give an opportunity to one or two people from the first panel to respond to the second. Boniface, I believe you have one or two people who might come in and say a couple of words, very short, just like 1 minute each, please.
You're on mute still, Boniface. You're on mute. We can't hear you.
So perhaps as we continue to wait for them to address the technical difficulties, we could begin to move to some of the
audience questions, begin to pull them up for all of the panelists to respond to.
Yeah, Erin, I could start.
Oh, here we go.
Okay.
Okay, sorry. I was saying, I have a paper, in fact, 2 papers that I have written that Boniface will circulate to the different panels at an appropriate time. But I wanted to say that the element of dangling reparations to influence victim commitment sort of undermines the depth at which we can get to the point of determining the reality of the situation on the ground. There's too much depth of information that could help us to move forward. And that is why we have a worry. The moment in managing the expectations for these reparations, the moment they are not forthcoming or they are not coming in the way they were expected, then we shall have a little bit of issues there. I also wanted to say that it was important for the prosecution to validate some of the information that they were being provided for about traditional justice. Mato Oput is just one of them. There are many other traditional processes that people go through. And these processes have been responsible for handling the multitude of ex-LRA, some more senior than Dominic Ongwen, who have returned to our communities. So I think it is invalid to say Mato Oput or traditional justice processes could not apply to Dominic Ongwen, and yet it has applied to many other people and many other LRA cases. I also like the comment about the inability of international justice mechanisms to deal with the specifics, especially the complex specifics, or I mean, the specifics in complex contexts like the one of the LRA. Now, it left out what many of the people would consider ingredients of justice. You see, because they do not understand, they are not exposed to it, they are not familiar to. Now, and then this now brings us to the question, who is not international and the victims, or is this local context not classified as part of the international community? And these are some of the things that undermine the ability of international justice to provide justice in certain contexts like this. I thank you.
Mari?
Okay, sure. So I wanted to turn to a couple of the questions in the chat that are worth picking up. There are a lot of really great questions, and unfortunately we don't have the time to take all of them, but let me just draw out 2. There's one question that is asking for a distinction between reconciliation and the extent to which punishment is deserved. So Aaron Aroma says, not to belittle the downplay the verdict of the court, the Acholi Mato Oput system is a reconciliatory system that is more concerned with the way forward after a wrong has been done than what punishment is deserved. So I was thinking that we could ask Ayo, Beth, and Ketty to very briefly whether or not they have a response to this, the distinction between this idea of reconciliation and the appropriate context in which Mato Oput could be implemented, and whether or not it's feasible when in fact others think that the deserving of punishment, retributive justice, is a more appropriate mechanism. So maybe just 1 minute each reflections on that one. And then I think it's worth thinking about. Annie Bunting has another question that actually will help us with the forward-looking discussion about that many of our colleagues have raised in relation to the programs, the initiatives. So Annie Bunting asks, directs it at Moses, but it's Moses and Evelyn and a range of other people who talked about what it takes to move on. What are the possibilities? What's viable? What do people need in order to move forward with their lives, to reclaim, to make it whole again after tremendous violence? And so the question is, what do you see as the best programs and initiatives to support children born in captivity? Are there good peer support for youth and families? And Bunting says that she would ask Evelyn the same question about the best programs and initiatives to support mothers and their children. I thought that would be a nice set of questions to take us moving forward as we reflect on what now, where do we go now? Reparations won't, by the time that kicks in, people will still be struggling, especially in the context of COVID, in the context of children still needing support, and the banishment that some are feeling as a result of this conviction and punishment. So would you like to, Keti, and would you like to respond to the first, Ayo, Keti, Beth, perhaps, this distinction? And it is a critique of your approach to thinking about the appropriateness of cultural and traditional responses.
I think I will take a stab at this issue. Thanks, Kamari. Just to confirm, can everyone hear me?
Yes, we can hear you. Go right ahead.
Thanks. So the issue before the ICC, the tribunal chamber, was where the defense counsel, Beth and Co, argued that the court should suspend the punishment that is going to be meted. If the court finds that Dominic is guilty, the court should suspend the punishment that will be meted out to him and ask that Dominic be placed under the authority of the actually justice system. That was a proposal which the defense counsel can make, which is fine. That doesn't mean the court will adopt it. But my point is that the court ought to evaluate it in a pluralistic way. What is Mato Oput? For those that don't, Mato Oput, rather, for those that doesn't understand, it means to drink a bitter portion made from the leaves of the Oput tree, and which is a mechanism of forgiveness and reconciliation among the Akoli people in Northern Uganda. And what does that drinking means? It symbolizes that the two conflicting parties accept the bitterness of the past and promise never to taste such bitterness. I believe that this Mato Oput could be integrated. Take, for instance, the creative way of doing it is maybe issue 10-year sentence. After 10 years, give him some credit for the time he spent in pre-sentence custody, and then ask that once he's done with his 10 years, he has to go through that Mato Oput. And also an aspect of that Mato Oput is the payment of money compensation after the ceremony. This ICC is still going to give reparation. So there's a way creativity that they can merge into both of them by acknowledging that this religious value or this justice-based system in Africa can still coexist side by side. But what did ICC do? No, it doesn't reflect the needs of the victim. No, we don't understand it very well. And again, in my larger discussion elsewhere, I've always said that the International Criminal Justice Project always, react negatively to anything that is not within the conventional civil and common law tradition, and that is a strong weakness that needs to be remedied.
Okay,
I'm saying
that's great. Okay, that's great. That's terrific, and there's scalar issues there, but we can continue that conversation. But that's really helpful, Ayo. Thank you, Beth and Keti. Anything very quickly? Only a minute, please, if you can, because we're running out of time.
Oh, is Keti going to speak? Or I have 1 minute. Do you hear me?
Yes, we can hear you.
Okay, I simply want to say, I don't want to repeat anything that's been said, but I think the question of reconciliation versus deserved punishment has to go to an underlying point. And that underlying point is who is being punished and for what. And I want to say the last thing, which is my client, Dominic Ongwen, said, I am not the LRA. He said that at his had its first court appearance December 6, 2015. And our position has been that the wrong person is in the dock. And I think this has to be inform any discussions about punishment, any discussions about reconciliation. And to me, the question going forward is, where is the political will in the international community to capture the person who is responsible for the LRA? This was a prosecution against the LRA. And Joseph Kony, in our view, should have been the person in that dock.
Okay, great. And Ketty, any last reflections? We'll give you just 1 minute.
Thank you very much. I think I agree with what Ayo said earlier on. I just want to say one thing, that reconciliation is an important element of this case. And for me, any process that further polarizes the community, us against them, this group against this group, will create even more damage than solve the problem that is there. As you notice already, the issue in Northern Uganda, people are divided over this case. And because people fall between both victims and perpetrators, my opinion would be that this point moving forward, we should aim at how do we build relationships between the various groups on the ground, whether it is through Mato Oput or whichever process. Relationship building, peaceful coexistence, to me, is the way forward. Thank you.
Great, thank you, Ketty. And Moses and perhaps Evelyn, just the last responses to this question about the way forward. I think it's a fitting way to think about where we go next. What are the best programs, initiatives? How do we think about the possibilities after the verdict? So where do we move from here? Perhaps Moses, Evelyn, can you share just 1 minute each, if you would?
Way forward,
Thank you so much. The way forward that can be done is reparation.
Victims. Machel car bu bale Mario du kombe murwen kombe chan jomu kano du Uganda eto tieno dong we Sudan keke mene kero kirojo kwone olo to kwe chunye.
Once a victim is given reparation, it's the most important thing, because some of them got muted, like their legs were mutated, and others are disabled. So the only way to support them is to give them preparation so that their lives are repaired. The reparation I'm talking about is paying individually, directly.
Okay, thank you. And thanks for your brevity. Appreciate it. Thank you, Evelyn. So Moses, is it?
Thank you. I would like to add something little, what Evelyn has already said. To me, I think reparation on the side of the children born in captivity, if there could be a program put in place to help and enable the children born in captivity access to education, medical help, and also something to help them attain a place where they can live, because many of us born in captivity have been rejected. Our mothers were rejected, so our mothers are struggling with us in the town and city areas. So now our mothers are busy renting, and they're really trying so hard to try their level best to push us in school and provide for us at the same time. So the challenge is most of us born in captivity due to rejection from our family members, our mothers' families, and the community where we come, where our parents come from. We don't have where to live. So if our mothers would be supported and gotten where to live, gotten land, as Katie mentioned earlier, land, the issue of land, so that our mothers can have where to live, where we call home. So access to education, to me, I think it should not only be access to education, it should be something qualitative and quantitative, something that can change the children's life for a long time. Not just putting them in school, attaining a given level of education, and then they start off from there. Something to help the children start life and push on with life. So such programs would be very helpful to the children born in captivity. I think that's where I stop now.
Great, thank you so much. So there are a lot of questions there, and we are pretty much out of time. So let me just share some closing thoughts with you about this symposium. We've certainly had a dynamic conversation, and it's clear that these issues are difficult. And in the context of violence, there are no winners, there are no easy answers, and there's a future that we have to ponder. Many issues remain unsettled in relation to remain unsettled in relation to the legal frameworks available to us and how they work alongside people's real world realities. People affected by war in Uganda also know how deeply structural the problems are. And at the same time, they also know that individuals, foot soldiers, make choices about how they deal with adversity, and that violence negatively impacts us all. Many have spoken about unresolved issues that the verdict did not address. Is it sufficient even to individualize responsibility for such wide-scale violence when so much of that violence is collective, or that we turn to the LRA as a larger machinery around which people, including adults over 18, did act and function? What about the category of case victims? The reality is that only some are included as victims that get particular types of compensation and reparations. But as we've seen, what about the children born in captivity? As Evelyn and others mentioned, what about the missing children, the dead children that were drowned in water? What about the ones eaten by animals in captivity? What do we do for these children, their families, and by extension, their communities? What about the divine and spiritual forces involved? What about the fear that compels people to kill, the coercion, and the resultant questions of mental capacity? And of course, what about the political and broader sense of conflict? What do we do about those narrow categories of victims and perpetrators in the context of such big and prevailing concerns? And so one of the core problematics that certainly has emerged today is whether or not the ICC and these larger mechanisms of international criminal justice actually have the tools to get us there. Can the ICC ever take seriously these cultural and traditional and spiritual domains through which people also live their lives and heal and try to reclaim their lives? But it's also clear on the other side that some insist that yes, the ICC has a positive role that it can play. Certainly, we heard that the ICC can play an important role in norm signaling, and some people who were victimized by violence and the war were relieved by this verdict. But of course, the tension remains, and beyond signaling and reparations, does the ICC have the tools to get us to the next step, the questions, the unresolved concerns that remain? Or are there other bodies, other mechanisms? What is the nature of the political for moving us forward? It's clear from this conversation that international criminal justice alone doesn't have the capacity alone to deal with the questions and the challenges that remain before us. For example, there was Sarah Kendall's question to IO, which responds to Lorraine Smith Van Lin's question, which was, how might we reinterpret Article 21C to include customary practices as part of national laws of states that feed into general principles? Beth also, in thinking about this question, asked about complementarity. Might we think about complementarity as a way to think about punishment, and not just through mitigating circumstances, but other larger conceptualizations through which we make decisions about punishment. And so, and many spoke about the complexities in which so many others were complicit in violence and the problems around the ways that we think about complicity. So moving forward then, one of the burning questions that remains very real to people today on the panel, on the sessions, is how do we envision our shared future? How do we ensure and move on to that future? What combination of justice modalities are best used for this purpose? And if in fact, as the session suggests, that justice has many sides, if it actually has many sides, what combination of sides can get us there? And so these questions remain and require that we continue to ponder these many sides of justice in relation to the work ahead. And one thing that is clear, or there are a number of things that are clear. One is that people need to be heard, that we need to listen, and that we need to listen well, that people feel that there needs to be a rectification and reconciliation of past wrongs. That is for sure. Violence is not okay. But beyond, and in relation to that, how do we move to the beyond? Through which people can survive and thrive and heal and move on with their lives. And so clearly there's a lot of work ahead as we think about after the verdict, as the session suggests. And again, there are no winners here, but what's clear is that we need to chart a path forward for a different future. And I thank you to all, to my co-moderators for the collaboration, to my colleagues in Uganda, to Isaac and Aaron, and I'll turn it over to them so they can close and thank everyone again. But really, I think what this this set of conversations has taught us is that the complexities remain there, and that there are ways that we can change them to make things better, that we can listen, that we can, those of us who are lawyers can work on reform, but those of us who aren't and that are working politically, there's significant work to do around these deeply political questions that are about structural injustice in our world, and in particular post-violence, post-war Uganda and the nature of violence there. So on that note, I'd like to just turn it over to Isaac and Aaron, who will thank everyone and lead us into the closing.
Thanks, Kamari. I will just do some thank yous and turn it over to you, Isaac. On behalf of the Transformative Memory International Network, the Justice and Reconciliation Project, and the Transitional Justice Project at the Critical International Summer School, we're extremely grateful to our audience members for calling in. We see from all over the world. Again, this will be made available as a recording so that you can continue to use it, hopefully in classrooms or public spaces, to continue the dialogue. We're also extremely grateful to each of our panelists who really without hesitation said yes to this invitation and have generously given 3 hours of their time to share their views, but also to listen to one another. And then thank you to Sarah and Tina, who are behind the scenes and making all of this move so smoothly, and to our special guest, Jeff Carando, for his endlessly beautiful and haunting music. Isaac?
Thank you, Dr. Erin and Kamari. I have very little to say. The sentencing of Dominic Ongwen is a beginning of another transitional justice efforts. With all the questions people have been raising, with the deliberations from the presenters, we can easily tell that there is a new effort that we need to put in order to really make this sentencing a turning point that is more sustainable positively into the life of particularly the victims community. I want to say thank you to the panelists. Thank you very much, Benjamin Gompet. Thank you very much, Ayo. Thank you very much, Katie. Thank you very much, Anuska, and the local participants from Uganda. Thank you to Vincent Oyet. Thank you to Charles Lapolo from Choron. Thank you to Evelyn Amoy. Thank you to Moses Komakech. And a big thank you to Prime Minister, Mr. Ambrose Ola. And a thank you to Jeff Corondo for the wonderful music. Just like Erin has said, we shall work together to make sure that some of these notes reach beyond these very important reflections. I want to thank other people who join us online and followed us carefully. Thank you very much for being part of these very important reflections. As I said, it's the beginning of another transitional justice era as we see into making a more meaningful outcome of this sentencing. Thank you very much. I wish you well.